Regardless of how the judge will rule next week, whether you think that this entire case necessitates any change to the current status quo or to put a structure in place for the whole talk about collective bargaining, whether you strike, when you get paid.
My friend, there is a structure in place. Our laws in relation to collective bargaining mirrors the law in the Caribbean. We have all the protective mechanisms that are there.
And it's
working. Some countries have gone further. They have established an industrial court. They have other legislation in relation to that court. I don't know whether we want to go in that direction, whether we have the type of activism here, the type of work here for that type of infrastructure. But it's a matter for consultation and discussions. The constitutional amendment process, reform process has just begun, so anything that you want to put in the Constitution, you have an opportunity to do so. Now, it was not done in a conventional way. It may not have been as successful as one of the parties may have wished. They may not have discussed all the matters that they should have, but that does not mean that there was no collective bargaining. Collective bargaining can be a loose, it can be an informal process. And in fact, out of this process, many benefits and policy measures, including financial matters, were discussed and implemented. Both sides accept them. It may not be the large number that the union felt should be. The union felt that salaries should have been included in the discussion. They were not, and that seemed to be the fact. But that doesn't negate the fact that even collective bargaining, that there is no right to strike in Guyana, there is a freedom to strike. That's an important thing. The Constitution has a right to demonstrate, a right to assemble, but a freedom to strike. The draftsman using language different language to portray a different concept.